Hi, everybody, and welcome to this morning's live stream. We're doing our live stream at a different time today because of the fact that after 6 weeks of trial, Alex Murdaugh has been found guilty. He's been found guilty of all counts, 2 counts of murder of his wife and of his son, and then also 2 counts of possession of a weapon in the commission of a violent crime for each of them. And this morning, we are going to have the sentencing. We have a special guest with us today, Taylor Bell. What was a guest with me on the Surviving the Survivor show a couple of nights ago. And I really thought what he had to say was very perceptive. And I had some questions about South Carolina protocol, and I thought he's the perfect person to ask. So Taylor was a public defender for 6 years. He's now in private practice. His focus is criminal law. He does criminal law, defending licenses, and that's professionals before their regulatory boards. And he also does DUI defense. So welcome, Taylor. We're glad to have you this morning. Thanks for coming.
Thanks for having me, Lee.
So some of the questions that I even can see already in the chat that I had, I was surprised when the judge said, well, guilty verdict. Okay, I'm ready to sentence, but it's late, so I guess we could wait. Whoa, I was used to sort of a longer pause in there, maybe weeks. With the Chrisleys, it was months. I think it was 6 months or more between the time they were sentenced or tried and found guilty and the time they were sentenced. And so tell me about that. In South Carolina, what is the protocol? We're going this morning. Last night, he said it's late tonight, and the state said, well, we can be ready at 9:30, and the defense said we can too. So tell me about that.
So typically, a defendant, if convicted, is sentenced right then and there, right after the trial. The opportunity to present any witnesses for mitigation is made, and also then the victims get the opportunity to speak. So what's going to happen today is Judge Newman, who I've been in front of numerous times and tried cases and unfortunately had clients convicted, he's going to call the lawyers and the defendant up to center. He is going to then give the victims an opportunity to speak, and speaking for the victims likely will be a victim's advocate. Maybe it will be a representative of all the family. Maybe it will be a lawyer that represents the family, or maybe it will be individual family members. And in this case, we've got several different victim classifications, because we've got Maggie's family, who has not really said anything about the case, not been there. So I think they're going to have somebody, or they are going to be there to speak. They've kind of let the legal process work its way out. And then you've got Buster. Buster is the son of Alec, who is Paul's older brother. He is technically a victim, even though he has been sitting behind his father the entire trial. So he's kind of in a position of, he supported his father throughout the entire process. So I don't know one way or the other whether he is going to speak, because in all...
he even testified. I mean, he testified on behalf of his father during the defense case.
He did.
And clearly in support of his father, in support of facts that were helpful to his father. So that's, if you have a groom side, bride side, and Alec is, I don't know, the bride, then I guess he's sitting on the bride's side. He's definitely in that camp, wouldn't you say?
I would say that. And I would also say that he's in a bad position, in a hard position, because, he's lost his family. He lost his mom, he lost his brother. Mm-hmm. And now he's, in all technicality, he has lost his father. He will never speak to his father again, from a position of outside of a monitored conversation when he goes to prison. So
let me ask you about that, because this is a life sentence, but depending on where you are in the country, well, okay, let me correct that. The possible sentences are anywhere from 30 years to life in prison, which 30 years could be theoretically less than life for him, but there are 2 different murders, and that doesn't even count the 99 financial crimes that he still has not been convicted of, but has essentially stated he's guilty of. So we've got that coming up. But what does that mean in South Carolina? What does
Okay.
it mean if you get a life sentence?
So most of our offenses are not considered day for day sentences. But a murder sentence, mandatory minimum of 30 years, is day for day. You do every single day of that 30 years, or whatever sentence you are given, you do every single day. If you were convicted of armed robbery, it's 85%. So, and then nonviolent, it goes down. So this, if he were to get the minimum, he'd do 30 years day for day. Now, if he gets life, it is life for the natural life of the individual. Now, compared to, some folks may recall a lady by the name of Susan Smith, who was convicted in South Carolina in the 90s for killing both of her children. And it was a death penalty trial, and it was either life or death. And she actually got sentenced to life. Well, that life sentence was actually the possibility of parole. This here, we do not have the possibility of parole for Alex. So it will be his natural life, meaning he will come out of the prison in a pine box, so to say. He will never step foot outside if he is sentenced to life. And ultimately, that's what I expect here. So going back, if I may, the judge then, after the victims speak, the defendant gets to put up his mitigation. The mitigation could be family members that want to speak on his behalf. And then he'll turn to the defendant and ask the defendant if he wants to address the court. I really don't expect there to be anything from Alec other than, I didn't do it, some pleads for, mercy. I mean, he's a narcissist at this point. We all see that. And I believe the jury saw that. And so he'll get up there and he'll say whatever he has to say. I'm not expecting him to get up there and all of a sudden admit to anything. And then I assume Judge Newman's going to give a few words of the wise and make comments about, and then I assume he's going to sentence him to life.
You mentioned the death penalty option that was on the table for Susan Smith. And I want to talk for just a minute about the fact that the death penalty was not on the table for Alex Murdaugh. And in this case, that my suspicion was that it was because of the fact that the evidence was a little close. It was not, there wasn't a video. There were more questions about it, but also because of the prospect of appeal and how long that takes, what an undertaking it is. And then my third thought was it probably would have been much more difficult to get in the financial crimes, because at that point, the judge would be concerned that he would be overturned if he tried to put something like that in. I also want to say a shout out to Kim Turner. Thanks for the super sticker. And but from inside South Carolina, what was your perception on why the choice was made not to go for the death penalty?
I think there are a few reasons. I think number one, political. I think, unfortunately, we live in a state that a lot of times there's only a certain group of people that actually get served with death notice here. I think the death notice was Timothy Jones out of Lexington, South Carolina, where I live. He was accused of murdering his 5 children, was convicted. He chopped them up, put them in a bag, and drove them, and was caught. There was a lot of drug use involved in that. He did get a death sentence. I knew all the attorneys involved in that case. But also, I think there was some political game there. I also think the manner in which how fast this trial went, because the motion for a speedy trial was filed, whether or not that could have been complied with a death penalty case, I do not believe so. I also don't believe that the attorneys on the case for the government necessarily had any death penalty experience. It was a state grand jury case. I'm not sure Creighton Waters had actually ever tried any murder cases. And you have to be death penalty certified from a defense perspective, but you also need to have the experience of death penalty cases. And John Metter surely did. But I also don't think that there was any experience on the government side in terms of a death penalty case. Now, also, I think the defense may have made a motion to be relieved as counsel if it was a death penalty case, because the amount of resources that goes into trying a death penalty case, you have the trial phase, and then you also have the sentencing phase. So again, also, I don't necessarily believe that the government believed they had a strong case. So if the government didn't believe they had a strong case to start with, then it could have been them falling flat on their face if they tried to, supposedly execute a human being that eventually was found not guilty or a hung jury, and then you don't even get to the sentencing phase. So a lot of political gaming was set forth in this decision. And I'm not sure the last time the Attorney General's office tried a death penalty case. Most death penalty cases are tried by the local solicitor's office, which South Carolina is broken up into districts or circuits. And so those circuit solicitors, they're the ones that handle most of the violent crimes. Our state grand jury typically handles multi-jurisdictional financial investigations, drug investigations, not necessarily your violent crimes.
So one of the things that I've been curious about is the fact that so many financial crimes came in. The judge went way out on the financial crimes. For example, I was particularly surprised that the check to the brother from years before came in. And it wasn't just a cumulative sort of introduction of evidence. It was actually referred to in the closing argument. They actually talked about the fact that he had stolen from his own family, not just from strangers. And so this is somebody who would be willing to hurt his own family. That was the theory behind it. It was, for those who aren't fully remembering the evidence, what that related to was a check that was cut to Alec instead of to his brother by mistake. They were both partners in the same law firm. The brother was owed some money, Alec wasn't. So Alec, for some reason that was never clear to me, got them to recut the check to him. He cashed that recut check and then months later cashed the secondary check. Apparently at the time, nobody thought it was that big a deal. He said, "Oh, sorry, my bad." And everybody sort of moved on, and it was brought up later and used at trial. Were you surprised that that evidence came in?
I think that was the crutch of the government's case, to be honest. I think without that, you didn't get the theory of that the storm was upon him. And that's what the government wanted to say. And they talked about that. The storm upon Alec, everything was falling down on him, and he had no other options at that point. And without that evidence, they would not have been able to set that picture up for the jury.
And I understand the motive, although I always thought that was sort of a weak motive. But that didn't really apply to the brother and the check. Nobody was worried about that. I thought that went really, that was, of all the pieces of evidence that came in, I still am sort of scratching my head that one came in.
So the 404B analysis is, and I think he looked at it as motive was the reason here. The prosecutors could never argue because he did this, that means he did that. They had to use it as he did this because of this reason, right? Because they couldn't argue propensity. So they had to argue motive. But I agree to a certain extent. I understand why it was allowed in. I would say that, a lot of our judges are former prosecutors, and they tend to see things from the lens of the prosecution. We have few that are former defense attorneys and a few that have done both. So it depends on kind of the lens, but I think he made a decision that was within his discretion, being the judge. It was a discretional decision. It wasn't, something that will be overturned. And so, I'm not the judge. I can't make that call. I would have been objecting to it coming in.
And I want to be sure we answer the question from Metroid Shellboy that I put up on the screen, who is asking about the prosecution mentioning they got little sleep and especially waters at a hotel. Is that typical for trials? It absolutely is. It absolutely is. For one thing, people often stay in a hotel just because they can eliminate all of the distractions that you have at home. You might have family, kids, things that will keep you from preparation. It is all consuming during trial. You leave trial and you're preparing for the next day because you've got to have your questions and you've got to know what they said at every moment in every deposition or every time they testify before. You need to know all that and have that lined up. So you are working around the clock with very little sleep. That's pretty common. And I guarantee you that was happening on the defense side too.
So on that note, you might not know this, that the defense was actually staying in a wedding venue there, and they had booked it prior to the prosecution reaching out to try to book it. So the news media has kind of made a big deal about them booking this $20,000 a week venue. Well, the prosecution called a few weeks later and tried to book the same venue. And on another note, this is actually the longest trial in South Carolina history. I learned that yesterday. So that's just to follow up a little factual tidbit.
Yeah, that's amazing. That really surprises me because although 6 weeks is long, it didn't seem, I mean, I've been in trials that were longer, so I'm just surprised that was the longest one in the history of the state. I will say this, the judge tried it hard. And by that, I mean, every day from, 9:30 till 5:30. It wasn't, 3 days a week or anything like that. It was tried hard all the way through with, I think, 1 day off for a holiday.
Yeah. So just follow up. There's a kid who was executed in South Carolina named George Stinney. And if you look up the history of that, we've actually got a poor history in quickly going through trials. It's much improved at this point, but that was back, where eventually the sentence on George Stinney was overturned, but I think I'm trying to say he might have been 15 years old, 14 years old, and his trial lasted less than like 3 days. I'm not sure off the top of my head it's insane as to what happened there. So we've come a long way, thank goodness. But yes, so we have a poor history when it turns to the length of trials and getting justice in this state.
Well, we're getting some questions I see running through the chat about SLED. And that was a question I had too, because boy, did they take a beating during the trial. There over and over, there were questions about what they didn't do, things that they missed, things that they overlooked, no footprints, no fingerprints in the feed room. And of course, Jim Griffin hit those things hard in closing argument, that these were things that could have exculpated his client. And if only SLED had done these things, there could have been some kind of way to prove that Alex Murdaugh didn't do the crime. He specifically talked about the fact that they didn't put Maggie's phone in a Faraday bag. And so as a result, what happened was her location data got overwritten because it was booted up and everything got overwritten. It didn't store the data for that long. So, and I just wondered, within South Carolina, what is the perception of SLED? Is it that this was either a one-off or just defense lawyers beating up on SLED because that's the only thing they have left to talk about? Or is the perception in South Carolina that there are real problems with SLED, which is South Carolina Law Enforcement Division?
So I wouldn't say overall there's a real problem with SLED. I'd say SLED is one of our more thorough investigative bodies here. Most of our cases, though, run through the local sheriff's department or the local city police station. SLED is the state agency. And so I'd say most of these folks are actually paid more than the local folks. They have a little bit more experience than the local folks. I'm not saying the local folks don't know what they're doing. All I'm saying is they do a more thorough job. And I think the investigation actually started out a little bit local, and then they called in SLED to do further because they needed additional support here. Now, I'm not going to bash that because I think they gave Alec the benefit of the doubt to start with, I believe, when they started their investigation. And that then at trial, the defense used that to try to, y'all didn't do this. But I think initially they were giving him the benefit of the doubt that he didn't have anything to do with the murders here. And at the end of the day, the defense tried to use the fact that they gave him deference and didn't, secure the scene right away, didn't collect these types of evidence, didn't test the hair that was found in her hand. All of that, I think they then used that to try to cut at the investigation by law enforcement. But overall, I tend to believe SLED did a thorough job here.
Yeah, Griffin specifically talked about the fact that they should have done all of these other things, about the fact that it would have given information he could have used to get his client off, and that he felt like from the beginning it was a rush to judgment against Alex Murdaugh, that he didn't feel like they were cutting him any slack. Now, in the community, I realized that there was a lot of talk about the power, the prestige of the Murdaugh family, and about how that insulated Alex from some investigation that other people might have had to undergo. But Jim Griffin's approach was, look, the day after the murders, they put out this press release that said, no danger to the public. And that's because they had already decided Alex Murdaugh was the guy, and he wasn't after the public. He was only after his wife and son.
Yeah, I'm not necessarily sure about the authenticity of the press release, though. I think we had witnesses that got up there and say they never authorized it, but it went out. It went out. And I understand where Jim was going. It was a really good theory there if they could have hammered home on it more. However, I think the introduction of body cam footage has really changed the prosecution and the criminal defense evidence available. It's really changed the game because we can sit there and see the context in which these discussions were had. Whereas previously, prior to body cams, we had to rely on a witness statement. We had to rely.
Taylor, let me interrupt you. The stream is coming on. Let's head over to that and show everybody. Okay. Notice that Alex Murdaugh is no longer he's in jail clothes now. He's no longer in the suit that he's been wearing throughout trial.
Bench is ready, Your Honor.
All right, from the state, Mr. Waters.
Thank you, Your Honor. We're obviously here in the sentencing for the state versus Richard Alexander Murdaugh. Your Honor, I have prepared the sentencing sheets signed up. If I can hand those up to the clerk. Your Honor, very quickly, the defendant has no prior record, and the state has no victim impact people who want to speak at this time. But I will address the court briefly. And I don't need, Your Honor, to repeat the evidence that Your Honor just heard for the past 6 weeks, but it is overwhelming. And it shows this man to be a cunning manipulator, a man who placed himself above all others, including his family. A man who violated the trust of so many, including his friends, his family, his partners, his profession, but most of all, Maggie and Paul. This is a very complicated situation, and I want to offer my condolences to the family that has suffered here. We have tried very hard to be respectful and sensitive regardless of what position any person took, because this family has suffered and they've had to suffer.
That means Buster.
And
yeah, you see Buster still sitting over there behind his father.
I want to offer it for Maggie and Paul and Mr. Randolph too, who I had the pleasure of working with.
He's on the
I can't see him.
4th row.
Okay.
The reality remains
He's sitting there by John Marvin. Him and John Marvin are
sitting
sitting next to each other.
Okay.
Maggie Murdaugh and Paul Murdaugh, and I'm so thankful that
Oh,
the
there he
jurors
is.
gave them a voice. You heard about Paul. Obviously, there was the boat case, but you also heard him described as a fun-loving young man, a person who loved life, a person who would do anything for his friends, for anyone. And he's cut down as he was just starting to live his life. You heard about Maggie. You heard how sweet she was. You heard that she was a girl's girl who adapted to the outdoorsman life of her sons, how much she loved her sister and her brother-in-law and their children. And she was cut down in the prime of her life. Both of them, like everyone else, was unaware of who he really was. No one who thought they knew this man.
That was a theme
No
throughout
one
the
who
case.
thought they were close to this man knew who he really was. And Your Honor, that's chilling. And I've looked in his eyes, and he liked to stare me down as he would walk by me.
He's taking it personal.
And I could see the real Alex Murdaugh when he looked at me. The depravity, the callousness, the selfishness of these crimes are stunning. The lack of remorse and the effortless way in which he lies, including here sitting right over there in this witness stand. Your Honor, a man like that, a man like this man, should never be allowed to be among free, law-abiding citizens again. I would submit to you that the only just sentence here to give justice for Maggie and Paul is the maximum, and that would be 2 consecutive life sentences. Thank you, Your Honor.
Consecutive meaning one after the other, as opposed to concurrent where they're served together.
Indicate that
That's what he was talking about.
No victim would like to speak at this time. Would any victim like to speak at any time during these proceedings?
Your Honor, one of the things we did early on, obviously, as I just said, it's a very complicated situation. But
I'm surprised
we
that
made the decision
Maggie's
early on.
family
We had our victim advocate
did not
here,
have somebody there
doing
to
a wonderful
speak.
job, regardless of the viewpoints of any individual family member, to provide
But maybe they don't want to hurt
aid and
Buster.
service to them. And we made that decision. I'm informed by our victim advocate that none of them wish to speak. The defense can certainly address that, but that's what I'm informed. But they certainly were offered the opportunity as is required. And I want to commend our victim advocate on the excellent job she did in handling this complex situation that we wanted to be sensitive to, because again, none of us are not mindful of the fact of the suffering of this family.
I know SLED Chief Mark Keel is here. Would you like to address the court on any matters, Chief?
Yes, sir. Just to say, again, very proud of our agents, the work they've done. I'm proud of the partnership that we've had with the Attorney General's office, as we've had for many years. And again, we're here to see the justice.
So that is Chief Kill. He is in charge of SLED.
For the defense.
Your Honor, Mr. Griffin and I would have no comment. The defendant would like to address the court, though.
Wow. Okay, now I'm surprised. I am surprised. Okay.
I'm innocent. I would never hurt my wife, Maggie, and I would never hurt my son, Pawpaw.
Thank you, Your Honor.
Thank you.
He looks very real in that emotion, in my opinion, right there. Not saying what he said was true. I'm saying his emotion is very real.
I don't think
There were
further
questions
comment.
earlier.
Thank you.
Mr. Murdaugh, if you'll come to the court for sentencing.
This is what I said. He'd bring him up, stand him in front of him.
Right.
This has been perhaps one of the most troubling cases, not just for me as a judge, for the state, for the defense team, but for all of the citizens in this community, all the citizens in this state, and as we've seen based on the media coverage throughout the nation. You have a wife who's been killed, murdered, a son savagely murdered, a lawyer, a person from a respected family who has controlled justice in this community for over a century, a person whose grandfather's portrait hang at the back of the courthouse that I had to have ordered removed in order to ensure that a fair trial was had by both the state and the defense. And I've sat through the trial. Not only have sat through the trial, but also as the presiding judge of the state grand jury, sat through and participated in the issuance of search warrants of various sorts, bond hearings, and have had to consider many things. And we have this case, and I'm also assigned to preside over 99 others, at least 99 other cases. Though testimony has come up regarding many of those other cases, I will not make any comment with regard to any other pending matter, as I have been assigned those cases as well. It's also particularly troubling, Mr. Murdaugh, because as a member of the legal community and a well-known member of the legal community, you've practiced law before me, and we've seen each other at various occasions throughout the years. And it was especially heartbreaking for me to see you go in the media from being a grieving father who lost a wife and a son to being the person indicted and convicted of killing them. And you've engaged in such duplicitous conduct here in the courtroom, here on the witness stand, and as established by the testimony throughout the time leading from the time of the indictment and prior to the indictment throughout the trial to this moment in time. Certainly, you have no obligation to say anything other than saying not guilty. And obviously, as appeals are probably expected or absolutely expected, I would not expect a confession of any kind. In fact, as I've presided over murder cases over the past 22 years, I have yet to find a defendant who could go there, who could go back to that moment in time when they decided to pull the trigger or to otherwise murder someone. I have not been able to get anyone, any defendant, even those who have confessed to being guilty, to go back and explain to me what happened at that moment in time when they opted to pull the trigger, when they opted to commit the most heinous crimes known to man. In this case, qualifies under our death penalty statute based on the statutory aggravating circumstances of 2 or more people being murdered by the defendant by one act or pursuant to one scheme or course of conduct. I don't question at all the decision of the state not to pursue the death penalty. But as I sit here in this courtroom and look around the many portraits of judges and other court officials and reflect on the fact that over the past century, your family including you, have been prosecuting people here in this courtroom, and many have received the death penalty, probably for lesser conduct. Remind me of the expression you gave on the witness stand. Was it tangled?
Tangled web, we weave.
Oh, what tangled web we weave. What did you mean by that?
And then when I lied, I continue to lie.
And the question is, when will it end? When will it end? And it's ended already for the jury because they've concluded that you continued to lie and lied throughout your testimony. And perhaps with all the throng of people here, they, for the most part, all believe, or 80, 90%, 99% believe that you continue to lie now when your statement of denial to the court. Perhaps you believe that it does not matter, that there's nothing that can mitigate a sentence given the crimes that were committed. You know, a notice of alibi was filed in this case by counsel in November, and we conducted a hearing, pretrial hearing, in which you claimed to have been someplace else at the time the crime was committed. Then, after all of the witnesses placed you at the scene of the crime, at the last minute, or last minutes or days, you switch courses and admitted to being there. And then that necessitated more lies and continued to lie. And I said, where will it end? It's already ended for many who have heard you and concluded that it'll never end. But within your own soul, you have to deal with that. And I know you have to see Paul and Maggie during the night times when you're attempting to go to sleep. I'm sure they come and visit you. I'm sure.
All day and every night.
Yeah, I'm sure. And they will continue to do so. And reflect on the last time they looked you in the eyes, as you looked the jury in the eyes. I don't know person who's always been such a gregarious, friendly person and cause their life to be tangled in such a weave, web, such a situation that yours have spun into. And it's so unfortunate because you had such a lovely family of such friendly people, including you, and to go from that to this. You know, your license to practice law has been stripped away from you. Turned from lawyer to witness, and now have an opportunity to make your final appeal as an ex-lawyer. And it's almost, it's really surprising that you're waiving this right at this time. And if you opt to do so, it's on you. You're not compelled to say anything, but you have the opportunity to do so.
It's not going to make a difference, in my opinion, Taylor.
Again,
No.
respect this court, but I'm innocent. I would never, under any circumstances, hurt my wife, Maggie, and I would never, under any circumstances, hurt my son, Paul.
Well, and it might not have been you. It might have been the monster you become when you take 15, 20, 30, 40, 50, 60 opioid pills. Maybe you become another person. I've seen that before. The person standing before
This is kind of a
person committed the crime.
key for Newman. He engages and tries to engage in a conversation with folks that get convicted.
I see.
He's already made up his mind, clearly. He compared it to death penalty
Before
eligibility, which it was. But for political reasons, I don't think that's
all
what
of the
happened.
other pending cases, are any of them here in Colleton, or I'm sure some of them are?
Yes, sir.
Half of them, or?
I don't have that in front of me, but there are a substantial number of charges here. There's some in Hampton, Orangeburg, Beaufort, Allendale. There may be others I'm not thinking of right now.
We might have worn out our welcome here in Colleton.
John Marvin is smiling at that joke.
I'll take this opportunity to thank Sheriff Hill and all of the court officials and really everyone I've met and dealt with while here in Colleton County. Just been great. But without any delay, we're going to schedule some of the other matters. I know Mr. Harpootlian's scheduling is complicated, and you've sacrificed quite a bit to be able to be here defending Mr. Murdaugh, as well as the Attorney General's office, with all the other many things and obligations you have. And to be able to have the Attorney General here, Alan Wilson, for the period of time that he's devoted to being here along with everyone else, it's been quite a sacrifice. But there are other victims whose cases deserve to be heard. And this case has jumped some of those other cases, perhaps jumped it because of this case resulting in an assault on the integrity of the judicial system in our state, law enforcement in our state.
Lee, I appreciate you having me here today.
Yeah, I should have mentioned that earlier.
July.
Taylor has a hearing he has to,
Past
so he had to
5 or
leave at
6
10. I
weeks.
really appreciate your coming and answering some of our questions. Thank you very much.
I
Good luck
appreciate
out
you
there.
having me here today. Take care.
To the wheels of justice, to be able to deflect the investigation. And as the evidence is pointed out in this case, the looming storm that Mr. Waters talked about, I can just imagine on that day, June 7th, when a lawyer is confronted and confesses to having stolen over $500,000 from a client. And he has a tiger like Mark Tinsley on his tail, pursuing discovery in the case involving the death of Mallory Beach. And having a father, for the most part, on his deathbed. I could imagine, I really can't imagine, but I know it had to have been quite a bit going through your mind on that day. But amazingly, to have you come and testify that it was just another ordinary day My wife and son and I were out just enjoying life. Not credible, not believable. You can convince yourself about it, but obviously you have the inability to convince anyone else about that. So if you made any such arguments as a lawyer, you would lose every case like that. Cases you will never have an opportunity to argue anymore, except perhaps your own as you sit in the Department of Corrections. Anything further?
No, sir.
All right, Mr. Murdaugh, I sentence you to the State Department of Corrections on each of the murder indictments in the murder of your wife, Maggie Murdaugh. I sentence you for the term of the rest of your natural life for the murder of Paul Murdaugh, whom you probably love so much. I sentence you to prison for murdering him for the rest of your natural life. Those sentences will run consecutive. Under the statute involving possession of a weapon during a violent crime, there is no sentence where a life sentence is imposed on other indictments. That is the sentence of the court, and you are remanded to the State Department of Corrections. And officers may carry forth on the imposition. Yes, sir. Yes, sir.
So Alex Murdaugh has now been sentenced to life in prison for the murder of Paul and life in prison for the murder of Maggie. Those sentences will run consecutively, so 2 life sentences if there were such a thing, and there will be no sentence associated with the possession of a weapon in the commission of a violent crime, just because what more can you do? And so there's not an additional imposition of years for that. There would have been had he been given the 30 years instead of life in prison. They're having a conference up at the podium, but I think we can go ahead and start talking. If they come back, I'll switch over to that. But the judge saying that he found his testimony that it was just another day at the office, that he wasn't really worried about the boat.
Before we adjourn, an order was issued concerning maintaining the juror's identity being anonymous. That order was issued, and for the most part, it's been complied with, except for the jury leaving the courtroom yesterday.
That's what somebody just asked
jury,
about.
But the defendant leaving the courtroom while the jury is still seated. Protecting the identity of the jurors is certainly extremely important during the course of a trial to ensure that no one makes contact with the jury or attempts to influence the jury. Jurors have a right to continue that privacy beyond their jury service, but they're not obligated to do so. And it would not surprise me if jurors choose to come forward and to speak, and they're encouraged to do so if that is their desire. I have no problem whatsoever with the jurors unmasking themselves and speaking freely with the media because they have undergone a life-changing experience and, as it relates to many of them. And some of them are here now. And I want them to know that should anyone attempt to harass them or annoy them, please let me know and I will address the issue. Secondly, there's a complaint now regarding the posting of autopsy photographs or photos that came from within the courtroom. It's based on the direction of the photographs. It did not come from the audience, came somehow from within the well of the court. The parties have requested an investigation of that. I have my hands full doing my job, and I don't attempt to conduct any investigations beyond the conducting of a trial, but to the extent that law enforcement decides to review that, that's would be the responsibility of law enforcement.
So it sounds like that was someone within the court is what he's suggesting who exposed that.
Of course, one of the reasons we've sought to seal graphic photos because the parties have a right to privacy and a right to those matters not being publicly disclosed. If anyone has heard about the recent settlement that Kobe Bryant's, another sports analogy, Kobe Bryant's wife just made with Los Angeles County and others out there over certain disclosures of information involving the death of Kobe Bryant. Liability can be substantial, and it's a risk for the most part that's not worth taking. So we'll let everyone judge themselves accordingly with that regard. Aside from all that, our business is done here in Colleton County, and I get to use my gavel one or few times during this trial and order that court be adjourned. Sine die.
And with that, it's over. Alex Murdaugh has been convicted of the murder of his wife, Maggie, of his son, Paul. He was also convicted of the possession of a weapon in the commission of a violent crime. But for those particular charges, they ended up being subsumed or taken care of in the course of the fact that he got a life sentence for the murder of Paul and a life sentence for the murder of Maggie. Those will run consecutively, so 2 lifetimes should he be able to come up with 2. The judge called Alex Murdaugh a cunning manipulator. He said that his family had controlled justice in that area, that the grandfather's portrait had to be removed from the courtroom before the case began because it might have prejudiced the jury. He said, "You've been before me as a lawyer, and now you're disbarred." He talked about the judge. He talked about the fact that his family, including he himself, had been a prosecutor. And I don't know that Alec had, but certainly others in the family had prosecuted others, and many had received the death penalty, probably for lesser conduct. But that wasn't even on the table here. The prosecution was not seeking the death penalty for Alex Murdaugh in this case. He asked when the line was going to end, posed that question, and Alex Murdaugh spoke very vehemently, denying that he murdered or would ever hurt his wife Maggie or his son Paul. Denied that twice during the course of the hearing. He did not say, "I'm sorry, sentence me to less," none of that. He said, "I didn't do it." And that was his final statement to the public, and he said it twice. Now, there will, of course, be an appeal. In general, criminal appeals are very, very rarely successful. Very rarely. That's true of appeals in general. It's really true of criminal appeals. And so his chances of that are small. The judge suggested maybe he had become, he said, I don't think anyone questioned that he maybe loved Maggie and loved Paul, but that maybe you became a different person when you took pills. He said the opioid addiction may have changed who Murdaugh was, at least while he was taking those pills, so many pills. He suggested they would start trying the financial crimes right away. And so that may happen quickly. He talked about Dick Harpootlian's schedule perhaps getting in the way of that, because they've now spent 6 weeks at this trial, but he suggested they'd be moving ahead anyway. And given that Alex Murdaugh has already stated he's guilty on so many of those, I would imagine there would be a plea deal that everybody would be considering rather than going through another trial, but we will see that. He's suggested that on June 7th, that financial storm was strong for Alex Murdaugh, and not just financial storm, but the family and the personal pride, I suppose you'd say, standpoint, because it was a lawyer he said had confessed to stealing over $500,000 from his client. I'm not sure that he had confessed that, but he in fact had stolen $792,000 from his law firm, and that he did confess to on the stand. He had also stolen money from his clients. Nobody knew that yet, but it was true. And it was something that he now admits and that is chasing him in the form of these financial crimes. That evidence came in at trial and was an important part of the closing argument, because Creighton Waters, the prosecutor, and the Mr. Metters, who went second, both said repeatedly to the jury, how can you trust him? You know, he lied, and Creighton Waters set up throughout the trial, we didn't know who he was. You thought you knew him. You thought he was telling you the truth and you could trust him. Turns out you couldn't. Turns out the whole time he was lying to you and you had no clue. And jury, be careful, because he's going to look you in the eyes and lie to you just like he did to them. And you should not believe that, because he's just plain a good liar. And that was the argument that they were making. He also suggested that, and he said, you know, that testimony that this was just another day for you is not credible. You can convince yourself of that, he said, but you can't convince me of that, because, and you didn't convince the jury of that. Clearly, things were not going well for you. Your father was on his deathbed. Your financial crimes were catching up with you. You were an opioid addict. Things were not fine in the Murdaugh household, no matter what you say. And now, of course, he has been sentenced, as I said, for 2 consecutive life terms. And as we heard from Taylor Bell before he had to leave, what that means in South Carolina is 2 consecutive life terms. It doesn't mean he gets out on parole. He doesn't get something for good behavior. He is sentenced to life in prison, period. That's what Taylor explained to us. Taylor was a South Carolina lawyer. He has a hearing, and we wish him well on that, so he had to travel to the hearing. I want to answer a couple of chats that came in real quickly. Rocky asked me about the line to the grand jury about the bloody t-shirt, and there was admission that there were several things that were stated to the grand jury that then were undone, worked back at trial. So you're correct that there was an overturning of that initially what had been said to the grand jury did not turn out to be correct. And Griffin, the defense attorney, said in the final closing argument, when you pull all those things away, all they have is the kennel video. All they have is the lie. But that lie was apparently enough for the jury. That lie that he showed up at the kennels when he said he was back at the house, that he wasn't there, wasn't around, that was enough to convince the jury. And there were other things as well. I don't mean to gloss over all of that. I just mean the issue about the blood spots on the t-shirt, that was walked back, because while those tested presumptive positive, when they were tested fully, it turned out to be not positive for blood. And so that was something that the state walked back. And Metter's response was, look, we didn't put that in evidence because we knew that didn't test positive for blood on the final test. Let's see. And we had another question from Metroid Shellboy who asked about whether or not about showing the jurors on the live feed. I did not realize they had done that. That was really appalling. And you heard the judge address that. The judge could not have been clearer that the jurors were not to be shown, that if they wanted to voluntarily go forth, they wanted to do interviews, they wanted to seek publicity, they were welcome to do that, but they were entitled to privacy. And so showing them had to have been a pretty huge mistake. There was no excuse for that. You may have noticed when they showed Alec walk back, they showed one person sitting in the jury box and focused on her for a while, but I don't know whether she was a juror and this was happening again, or whether she just happened to be sitting there in the jury box. She may have even been a member of the court. This has been an amazing journey through this trial. I don't know that there are many trials that have so many twists and turns as this one. The fact that Alex Murdaugh is that he is about to be on trial for not just the murders of his wife and son, those were just the first of the charges against him, but for 99 other financial crimes. He also has yet to be charged federally and almost certainly will face additional charges over there, particularly tax evasion, since he's already been charged with state tax evasion. Almost surely the federal tax evasion charges will follow. So we now know Alex Murdaugh has been sentenced to life in prison. He probably would have been facing that in any event because of the financial crimes. Now it's going to be even more certain because of the fact he already has that sentence for the murders of his wife and son. Now he clearly plans to appeal, and there's no question that that will be happening, but he will be in jail throughout that time, and his chances of winning on appeal are remote. His primary issue almost certainly will be the fact that the financial crimes were admitted, and he will argue that those prejudiced the jury against him. So if you would, please like the video. I always forget to say that. And also, if you would, please subscribe to the channel. What we do here is follow legal cases. We'll be following the Lori Vallow Daybell case by popular demand. We will also be following the Dan Markle case out of Florida. And I do mean popular demand. I have had a lot of requests for that. So, and we're going to be following all of the best cases, the most interesting cases, the ones with the biggest twists and turns. You don't want to miss a minute. This has been great following this case with you. I will continue to bring you updates as we learn more about what will happen with the financial crimes and what will happen. I also want to bring you a specific update on Buster, who I think came out with true tragedy here. He's lost basically everything. A little bit of it was his fault, but most of it, the vast majority, had nothing to do with what he did. And so I do want to do a little bit on that, and I will see you in the next video.